Can you give the jury any insight based upon the evidence in this case as to whether or not Mr. Zimmerman evidenced a warrior mindset or not?
Based on the information I received from probably one of the most important persons I talked to with that regard was Mr. Pollock, the gym owner. And his description and everything about Mr. Zimmerman was not one to enter in the ring. He was not confrontational. Everything that I've reviewed in this case would indicate the opposite. He was not the type that had what we would refer to as a warrior mindset, that inner fire that compels you to be a fighter, that compels you to be that person that wants to get into the ring to test your skills against another person.
Was there anything about but for the gunshot, the lack of injuries on Mr. Martin that helped you with that decision?
Based on the injuries that we've all seen for Mr. Zimmerman and the lack of injuries on Mr. Martin, I would take that as evidence that he didn't have any striking. Even though he's on the ground and in this tussle, he did not do anything of any significance that would have been able to even result in an injury to a man. So that would support, again, the same information that I already derived from another source.
He didn't even land a strike, at least one that left a mark, did he?
There doesn't...
Object that as call for speculation.
Sustained.
How about any evidence gathered from this event that suggested that Trayvon Martin did have a warrior mentality or mindset?
That is beyond the scope and in violation of a limited motion.
My response?
Sustained as to the violation.
The door was opened, Your Honor. It was this prosecutor that asked that very question. I'm just asking him to focus.
And you've already asked your questions about that, so I think that...
I'm now asking about Mr. Martin, not Mrs. Zimmerman any longer.
My objection, my ruling remains sustained.
Yes, Your Honor. Was there any evidence in the case that you've looked at that would suggest that even through the 45 seconds worth of screaming that the attack stopped?
Judge, I'm going to object to that as call for speculation.
Well, you asked him if he was aware of any evidence overall.
No, I saw nothing that would indicate that to me.
Thank you. Nothing further, Your Honor.
Okay, thank you. May Mr. Root be excused?
Subject to recall, Your Honor.
Okay, thank you very much, sir.
May we approach on the issue of recall for a moment?
We can address that later, but I will tell him you're subject to being recalled. And then we'll address the issue about recalling later. You're excused from the courtroom today, but you're subject to being recalled. Please call your next witness.
Just have a moment.
Yeah.
Thank you for the time, Your Honor.
Okay, thank you. Call your next witness.
Ms. Bertolone.
Do you solemnly swear or affirm that your testimony in these proceedings will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
You may proceed.
Thank you. Got the name, ma'am. Could you state your name, please?
Olivia Bertolin.
Okay. And Bertolon, if you would spell that last name.
Bertalan.
And at one point, back in February of actually early 2012, did you live in the retreat at Twin Lakes area?
Yes.
Have you since moved out?
Yes, I have.
Okay. Are you married?
Yes, I am.
Do you have any children?
2.
Okay. And their ages?
2.5 and 4 months.
Okay. Going back then to when you still lived at Retreat View Circle, did an event happen at your residence where a crime was committed?
Yes.
If you would explain to the jury what happened with that.
I was home on a Wednesday with my son. He was, I think, 9 months at the time. And I heard someone ring my doorbell repeatedly. So I went to check upstairs because I didn't have a peephole. And I saw two young African-American guys ring my doorbell repeatedly, and they kept on looking up at the window. And I called my mom because I didn't know what to do. And they left. Then after a while, I went back upstairs to check one more time. And they were walking in front of my house. One came towards my house. And I was on the phone with my mom at the time, and I started crying. And I called the police. They broke into my house. I heard some bangs downstairs. The dispatcher told me to grab any weapon I had because I had my son in my arms. He had woken up, and just prepared to use it if I had to. The guy was I was locked in my son's bedroom, and he was shaking the doorknob trying to get in. And I was sitting there with a pair of rusty scissors and my son in one arm, and the police came and they ended up leaving.
And do you recall approximately when this happened?
August 3rd of 2011.
And did you then take a place of refuge or hiding while this was occurring?
Sorry, yes, I did.
And where did you go to hide?
My son's upstairs bedroom.
In the closet?
I wasn't in the closet. I was in the far corner because the closet was closer to the door. So she said to get away, as far away from the door as possible.
And did you have your son with you during that time?
Yes, I did.
Did the people who were downstairs at some point, did they leave the house?
Yeah, once, I guess they escaped before the cops got there.
And did they take any items with them?
Yes, they did.
What did they take?
My camera, our laptop, they tried to get our TV. It was unhooked, but he had it hooked up to our computer, so they couldn't get it off. I think there was something else, but I can't remember what it was, but definitely our camera and my laptop.
And at some point, then one of those people, or at least one of those people, were arrested and found and arrested and charged with that crime?
Yes.
And do you know what happened? Do you know the person's name?
His name is Emmanuel Burgess.
And is that the reason why you moved from that area?
Yes.
Nothing further.
Just briefly, thanks. Ms. Berlin, good afternoon. You had some contact with George Zimmerman after that event, did you not?
I did.
Okay, and
Direct, outside the scope of direct.
Judge, it's the basis of her testimony, I believe.
I would ask that that be proffered at the bench.
Well, we can't proffer to the bench. Ladies and gentlemen, if you'll please put your notepads face down on the chair and follow Deputy Jarvis out of the courtroom.
Ms. Berlin, I believe you said that this crime happened to you on August 3rd, 2011.
Yes, sir.
Did you have contact with George Zimmerman that day?
I did.
Okay, when I say George Zimmerman, I'm referring to the gentleman seated at the end of the table to my left. Correct?
Yes, sir. Yes, sir.
All right. He came to your house,
Yes.
and he gave you his phone number.
Yes.
And the reason he came to your house, as he described to you, was that he had heard you had been a victim, right?
Yes, sir.
And you talked to him about it, correct?
Yes, sir.
You described the people that you saw at your residence?
I believe so.
You described them as two people as opposed to one?
Yes.
As males?
Yes.
As black?
African American, yes.
As teenagers?
Yes. I said they looked young.
And that wasn't the only conversation you had with this defendant about that case and you becoming a victim, right?
Right.
Is it correct to say that you and he talked about this approximately 20 times after that?
Probably around there.
I'm sorry?
Probably. Around that amount.
And you discussed with him the fact that the person had not yet been caught?
I'm sure I did. I spoke to several people about it.
And the person wasn't caught until after you moved out of the retreat at Twin Lakes, right?
He was arrested in December. Then he was released because he was a minor, and he was arrested again after we moved out.
After you moved out.
I believe so. We got a letter after we moved out. I'm not sure the exact date of his arrest.
And another thing that you and George Zimmerman discussed was where you believed, or he believed, that particular suspect lived, right?
I'm sure we discussed that.
And you discussed that he lived near the back entrance of the retreat at Twin Lakes?
Yes.
Your Honor, I have other questions for, but they don't relate to her contact with the defendant.
Okay.
So that would be the extent of the proffer, I believe was what was objected to.
I withdraw my objection.
Okay, thank you. Let's go ahead and bring the jury back.
Ms. Berlin, I believe you said this incident happened to you on August 3rd, 2011.
Yes, sir.
Okay. That day, did you get a visit from a man named George Zimmerman?
I did.
All right, and is he the gentleman seated to my left at the end of the table?
Yes.
He used to live in your neighborhood, right? He used to live in your neighborhood.
Oh, sorry. Yes.
And he actually came to your house that day, correct?
Correct.
I need you to just speak out loud. And he talked to you. The reason he came to your house, he didn't know you, right?
Right.
He came to you because you had been a victim of something, right?
Yes.
And you described for him what had happened to you that afternoon.
Yes.
And you described to him the people that had victimized you, right?
Yes.
And you described the number of people.
Yeah.
How many did you tell him?
2.
And did you describe the sex of the people?
Yes.
And what was that?
Male.
Did you describe the race of the people?
Yes.
What was that?
African American.
Did you describe the age of the people?
I didn't know the age for sure, but I'm sure I told him I assumed they were late teens. They looked that age.
And after that, you and he continued to talk about that very case, right? Mm-hmm. Yes?
Yes.
Okay, approximately 20 times. Is that fair?
Yeah.
And you and he discussed that the person or persons involved had not been caught, right?
Right.
And you discussed that it was your belief, and I say your collectively, you and him, that that person responsible or one of the people actually lived in the retreat at Twin Lakes, right?
It was confirmed by the police.
That they lived inside.
Yes.
And you discussed that with the defendant.
And other neighbors.
And you discussed that that person lived in retreat at Twin Lakes near the back gate, right?
Yes.
And then it's your understanding that at some point that person was arrested
Yes.
and released prior to February of 2012.
Correct.
You have you watched the proceedings in this trial?
Briefly.
What parts did you watch?
I believe I saw his uncle testify.
Who else?
I don't know any by names. I haven't watched very much.
Have you tweeted about this case?
Not since, no, I have not.
Not since what?
Maybe last year when it first happened.
You haven't tweeted about this trial
I don't believe so.
this week?
I don't believe so.
You do have a Twitter account, correct?
Yes.
And you follow, you actually follow Mr. O'Mara, do you not?
Yes.
And you follow an account or a site called Zimmerman Legal Case, right?
I do.
And you have been on Nancy Grace
Yes.
in regards to this case.
Over a year ago, yes.
I have just a moment, Your Honor. Ms. Berlin, thank you for your time.
Redirect.
Just a few follow-up questions, ma'am. When Mr. Zimmerman came to you to talk to you about having been victimized by a home invasion. Did you consider that strange?
No,
Were you appreciative of his efforts to help you out?
very.
Tell me about that.
We were terrified when this happened, and when we came home after we were having car troubles, and we came home, and he was just saying that he wanted to make sure we were okay. We weren't home, my sister was, and she didn't answer the door because she was scared because of what had gone on. So I was just appreciative that he was offering his hand and had told me I could spend time with his wife if I needed to go somewhere during the day because I was so afraid.
He told you that his wife Shelley was a nursing student, correct?
Correct.
No objection as to hearsay.
Did he tell you, what did he tell you about his availability, if any, of his wife to be there for you if need be?
Judge, I object to that as to hearsay and relevance.
It's,
Well, I'm really having a problem with the relevance.
I was just following up, but, okay, Your Honor, I'll just focus it again. Were you aware that Ms. Zimmerman was there for you as well, if need be?
Yes, sir.
Did you then at some point, shortly thereafter, go to the homeowners association and discuss the issue of the home invasion?
I don't believe I went. My husband did.
And then, in addition to your conversation with George Zimmerman, did you talk to other people about what happened to you?
Yes.
Who's that?
A couple of my neighbors, a neighbor named Pete, another neighbor, Chris.
Was this home invasion then something of a point of conversation because of the trauma that you had with it?
Yes.
Matter of fact, did Mr. Zimmerman, after the homeowners association that started Neighborhood Watch, did he bring to you a lock to help you with the sliding glass door?
Yes, he did.
Did you consider that weird or unusual or strange?
No, I was very appreciative.
Were you made aware that there was a issue with problems with the sliding glass doors in your neighborhood?
I don't believe so.
Was it actually how they got in the house, a sliding glass door, or another?
Yes.
So they actually came in through the back sliding glass door?
Mm-hmm.
Did
Yes.
this lock then help secure that problem?
Yes, it sits behind it, and it locks it tight so they can't pull it open.
And before you moved out, you even had, didn't you get a dog to help?
Yes, we did.
Was that part of trying to just stay more secure in a neighborhood where you've been burglarized or invaded?
Yes, the cops told us to get a dog.
You know the person who was arrested was Emmanuel Burgess, you said,
Yes.
and that he was released?
Yes.
Did you know that he was rearrested on February 6th of 2012?
I didn't know when. I got a letter after we moved out, so I didn't know exactly when he was arrested.
Did any of your interactions with Mr. Zimmerman in this regard leave you with some impression that he was just too involved in trying to help you out?
No,
Did you think that his behavior was helpful to you?
very.
Still have the dog?
Yes.
Thanks very much. Nothing further.
Thank you. May Ms. Bertolone be excused?
She may.
Yes, sir.
Thank you very much. Your
Call Robert Zimmerman Sr., Your Honor. Thank you, Your Honor. Good afternoon, sir. State your name, please.
Robert Zimmerman.
And live here in Central Florida. George Zimmerman as your son, I imagine?
Yes, sir.
Okay. Understand, of course, he's here on a second-degree murder charge, right?
Yes, sir.
I'm going to limit my questions to you to an event where you had an opportunity to hear what we have been calling a 911 tape, or Miss Lauer's 911 call. Do you know what I mean when I ask you about that?
Yes, I do.
It is a tape that includes in it some screams and a gunshot. Have you
Yes, sir.
heard that tape?
Yes, I have.
We have it available. The jury has heard it dozens of times now. I'll only play for you if you need it to hear it again, but do you have a memory of it such that you remember listening to it and forming an opinion as to who you heard?
Yes, sir, I do.
If you would just tell me the setting or the circumstances around the first time that you heard it.
I believe the first time I heard it, it was on the 3rd floor of this building. It was in the state attorney's office. I was there, I was put under oath. They asked me some questions. As I was getting ready to leave, they asked me if I would mind listening to this tape. I said, certainly. So they took me in a fairly small room where there was a computer. They provided me headphones, and they reminded me I was still under oath and would I listen to it. I said, yes. So I listened to it. And then they asked me, did I recognize the voice?
And what did you tell them?
I told them, absolutely, it's my son George.
Is that an opinion that you still have through today?
Certainly.
Nothing further on.
Thank you, Cross.
Call Robert Zimmerman Sr., Your Honor. Thank you, Your Honor. Good afternoon, sir. State your name, please.
Robert Zimmerman.
And live here in Central Florida. George Zimmerman as your son, I imagine?
Yes, sir.
Okay. Understand, of course, he's here on a second-degree murder charge, right?
Yes, sir.
I'm going to limit my questions to you to an event where you had an opportunity to hear what we have been calling a 911 tape, or Miss Lauer's 911 call. Do you know what I mean when I ask you about that?
Yes, I do.
It is a tape that includes in it some screams and a gunshot. Have you
Yes, sir.
heard that tape?
Yes, I have.
We have it available. The jury has heard it dozens of times now. I'll only play for you if you need it to hear it again, but do you have a memory of it such that you remember listening to it and forming an opinion as to who you heard?
Yes, sir, I do.
If you would just tell me the setting or the circumstances around the first time that you heard it.
I believe the first time I heard it, it was on the third floor of this building. It was in the state attorney's office. I was there, I was put under oath. They asked me some questions. As I was getting ready to leave, they asked me if I would mind listening to this tape. I said, certainly. So they took me in a fairly small room where there was a computer. They provided me headphones, and they reminded me I was still under oath and would I listen to it. I said, yes. So I listened to it. And then they asked me, did I recognize the voice?
And what did you tell them?
I told them, absolutely, it's my son George.
Is that an opinion that you still have through today?
Certainly.
Nothing further on.
Thank you, Cross.
Listened to it 6 times, is that correct?
I'm sorry?
I think you've listened to that recording 6 times, correct?
No,
You have not?
no.
Okay. I may have a moment, Judge.
Yes, you may.
I've listened to it a number of times. I have no idea if it's 6 or,
Oh, okay.
I would probably say at least 6, but
More than 6 times?
I would
least-
guess at least 6, but
Okay.
I really
Thank you very much.
can't
sir.
be accurate.
Thank you, sir.
Okay, any redirect?
No, thank you, Your Honor.
May Mr. Zimmerman be excused?
Yes, Your Honor.
Subject to recall, Your Honor.
Okay, thank you. You're excused from the courtroom, subject to being recalled, sir. Thank you. Call your,
I think this might be a good time for a break, if I might, Your Honor.
okay, ladies and gentlemen, we'll take a 15-minute recess. If you'll please put your notepads face down on the chair and follow Deputy Jarvis back into the jury room. Please be seated. Is the defense going to be calling any other witnesses?
No, Your Honor.
Okay, so after the recess, I'm going to ask Mr. Zimmerman about whether or not he wants to testify. But at this time, Mr. Zimmerman, were there any other witnesses that you wanted your attorneys to call on your behalf, sir?
No, Your Honor.
Okay.
For this hearing?
For this trial?
The trial.
You've been here through the trial, and we've had, let's see, we've had 40 witnesses that were called by the state and 19 witnesses called by the defense. Some of them were called, I'm sorry, I'm talking to Mr. Zimmerman. Okay, some of them were called a couple of times, such as Ms. Singleton, so it's really less than 19. My question to you is, Mr. Zimmerman, were there any other witnesses that you wanted your attorneys to call on your behalf at this trial?
No, Your Honor.
Okay, thank you very much. When we get finished with the recess, I'm going to ask you about whether or not you're going to testify.
Yes,
So
ma'am.
take the time you need to talk to your lawyers.
Thank you.
Okay, thank you very much. Court will be in recess.
By stipulation, so they're now in evidence. I don't think that the court needs to address those. Since we are on the verge of closing, there was one composite exhibit that the state is going to just review momentarily and then not have an objection. That will be the last one that's going to be entered in by stipulation.
So that would be composite exhibit 30?
Yes, actually, yes, it's only one document. It's just 7 feet long. And it's a
Oh,
composite.
okay. What is it?
It is a timeline.
Okay, defense timeline? Okay,
You give
Mr.
the,
Your Honor, we just want to verify some of the times on there, and it took us a little while, but
Sure.
I told, other than that, we won't have an objection, assuming it's accurate. I'm not saying that it isn't, we just want to be able to have some time to verify that.
there are only 2 other slightly loose end. I'm sorry.
Whoever wants to speak first.
Go
Go ahead. No. Go ahead.
While we're out, the items that were stipulated to, they had to be marked, and those items contained item 30, so we were already up to item 30. And the next one would have been 39 for the
I'm sorry, I don't understand what you just said.
They had me mark them for exhibits, and then they stipulated to them to be entered into evidence and had me mark them for evidence. So I marked them items 30 through 38.
Okay, I don't understand what you're saying they are, because what Mr. O'Mara showed me is
All
a
of these
long
exhibits.
line.
I'm sorry, if I might, these are now in evidence as 30 through 38,
Okay,
and we'll identify those for your list. You want me to go through them?
I do,
Okay.
30 being,
Give me,
Your slide.
okay,
It's going to be on the wall.
all right, I'll take care of them. 30, Your Honor, is a picture of the back of Mr. Zimmerman's head.
31,
31 is the front of Mr. Zimmerman's head.
okay,
32 is still photograph of Mr. Martin in 7-Eleven. 33, a picture of Mr. Martin's pants. 34, a second still of Mr. Martin at the 7-Eleven. 35, a aerial view of the retreat at Twin Lakes, I'm sorry, area of inquiry. 36 is a larger aerial photograph of the entire area of that portion of Sanford. 37 is a large aerial of retreat at Twin Lakes. And then 38 is a medical ME investigator's picture of the scene. Then if admitted, then 39 would be the timeline we talked about. There are two other loose ends. One is what we talked about with the judicial notice of the weather. We came up with a more accurate one for the 26th. That's going to be substituted, and that's close to me, but not in my hands. And I'll get that to you as soon as I can.
is that stipulated as a substitution for State's Exhibit 213?
Yes.
Okay, so as soon as you get it, Trish, will you allow that to be substituted for the one you have?
And the
Right.
next one would be the same exact type of exhibit for the 27th of February.
That's correct, Your Honor.
Do you want that as composite at State's 213, or do you want the other one?
We planned them as separate so that we would not mess up the clerk, so the
Okay.
substitution would be for the
So
26th.
we'll substitute 213 for the new one, and we'll make the second one for the February 27th, Defense Exhibit 40.
Yes, Your Honor. And the- Yeah, I'll do that. And, Your Honor, the only other one was that there is an exhibit that, in order to move matters along when Ms. Gentile was being questioned, we used a very small portion of the CD to question her. And we acknowledged to the court that we would present to the court that as its own, just redaction of its own one portion of it. So that hasn't been brought into evidence yet. That needs to be presented as well, because we used that, if you might recall, to refresh her recollection as to what she said, but we used the entire interview of her, which would not be appropriate to go back to the jury, just the one portion that was played. And we're going to get you that CD, and that's the last matter.
My recollection is she was just able to either listen to it or something, but not in front of the jury.
It wasn't played in front
I
of the
don't think it
jury.
was. I
The
think it
jury was sent out.
Yeah.
And I said, since it wasn't impeachment, so it wasn't played in front of the jury.
I might just have a moment, Your Honor.
Yes, you may.
Just to be clear, my understanding was that the part that, and I may just be wrong, and I apologize, I understand that the part that was played was the portion of it that's where she said that could be Trayvon, that might be Trayvon, and those words, and I believe the jury was present.
Okay, they weren't, but let's do, if we could get the court reporter's notes from the date that Ms. Gentile testified. It was two different dates. I believe, is it Defense Exhibit Double D? Is that how it was identified? Because I have that as a tape of Gentel interview with the state attorney's
I believe it
office.
was, Your Honor.
Is that
Yeah, it
DD?
Yes,
It was
and I
not
think-
played in front of the jury, but we can verify it. Is there any way to get? Okay.
Tell you what, it looks as though there may be an issue. We will have some time between now and the time the jury would get it. We'll take care of fixing it and letting you know. The only concern was that this is now in evidence as DD, and this is...
Not in evidence, it's
Oh, I'm
identified.
sorry. So this is just marked, I apologize.
It's marked for identification purposes.
Yes.
Okay, were there any more of those house,
The state has to look at it to confirm, and we'll be in Thursday.
any more housekeeping matters?
We'll get you the weather information. I think that's it, Your Honor.
Okay, Mr. Zimmerman, please stand up. I'll remind you, sir, that you're still under oath from when we had you sworn in earlier before the break. Did you now have sufficient time to discuss with your attorneys whether or not you wanted to testify in this case?
Yes, Your Honor.
And I don't need to know what was said, but after those discussions, have you made a decision?
Yes, Your Honor.
And what is your decision, sir?
After consulting with counsel, not to testify, Your Honor.
Okay, you understand that no matter what counsel says to you, it's still your decision. Do you understand that?
Yes, Your Honor.
Okay, and I need to know, is it your decision to not testify in this case?
Yes, Your Honor.
And are you making that decision freely and voluntarily?
Yes, Your Honor.
Has anybody promised you anything to get you to make that decision?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
And this is clearly the decision that you yourself have made.
Yes, Your Honor.
Thank you very much. Is the defense going to rest subject to any more evidence being entered? And
That's correct, Your Honor. Thank you.
is the state going to have rebuttal evidence? Testimony?
Yes, Your Honor.
And how many witnesses are you going to be calling for rebuttal?
Have at least 2 today, and one who is not available today should be available tomorrow, which we may not end up calling anyway.
Okay, I still haven't seen the proposed jury instructions. It's my understanding that a copy has been provided to the defense and a copy has been provided to Mr. Zimmerman. Is that correct, sir?
Yes, Your Honor.
Okay. Can I please have a copy? Are these 2 witnesses going to be lengthy?
I don't think so, Your Honor.
Can we do a charge conference after we excuse the jury for the day?
I don't see a reason we can't.
We can start. We have some special jury instructions to prepare and present, but we can at least get a feel. I think might now be the time for me to renew my judgment of
Right,
acquittal.
and then you'll rest in front of the jury and we'll go forward.
Yes.
Okay, you may proceed.
Presentation to you earlier, I'm going to certainly abbreviate and not readdress the arguments nor the case law that I addressed. I would certainly ask you to reconsider those. I think that the factual basis, however, has changed somewhat, and I'm not going to recount it because I know that you were sitting here along with us during the whole time of hearing it, but that the defense case has presented now evidence that I believe, uncontroverted evidence, that supports my client's contention that he acted in self-defense. That includes, of course, the most recent witness, Mr. Root. It includes Dr. DeMaio and his expert testimony in regard to the gunshot, and also the other information concerning the injuries that my client suffered. We also have a number of voice witnesses, if you will, those witnesses who have come back and testified before this court that they had no issue whatsoever and were quite firm in their position and belief and testimony under oath that it was my client who was screaming for help. And again, I don't want to belabor the point of the previous case law, but I think that you would need to decide at this point, basically, that there is, that the state has excluded at this point in the trial a reasonable hypothesis of my client's innocent. And now with the strength of the defense presentation that they have failed to do so, and I would ask that the charges be dismissed in full.
Response?
Thank you, Your Honor. If anything, the state's position is that Dr. DeMaio certainly portrayed at least one alternative scenario where the defendant could absolutely have committed second-degree murder against Trayvon Martin, just by virtue of his answer to Mr. Delarianda's questions, that being that Mr. Martin was attempting to pull back or disengage when he was shot and murdered by this defendant. Moreover, to say that Mr. Root's testimony was uncontroverted is, I think, overstretching it even more than Mr. Root did. Certainly he was very eager to draw conclusions, but he also had to admit finally that he had absolutely no idea what exactly went on at the moment that this defendant shot and killed Trayvon Martin. So we believe that while the defense may have presented people to sort of enhance the dispute of facts and the inferences that can be arisen, in other words, to make it perhaps even more disputed, that the state has certainly submitted sufficient evidence and will again continue to do so in rebuttal to indicate that both the facts and the inferences that can be drawn therefrom would support a jury verdict as to both murder and the lesser included manslaughter.
Very brief response. I would just ask that either the state or perhaps the court, if you're going to rule, come up, or identify the state's factual scenario, their theory of the case, anything for which there is, that excludes a reasonable hypothesis of innocence of my client now that they finished their case and we've finished our case. I would ask that that be articulated in some form or fashion, either by the state so that you can make the ruling or by the court in your ruling that actually suggests that legally this judgment of acquittal should not be granted.
Okay, thank you. The court has sat here and listened to all the witnesses. I think I had previously said how many witnesses had testified both on behalf of the state and the defense, and have listened to the arguments both at the end of the close of the state's case and now at the close of the defense case. And the court's decision is the same, that there is substantial evidence, both direct and circumstantial to allow this charge to go to the jury. So we need to bring the jury back in. You need to rest in front of the jury, and the state be prepared to call your first rebuttal witness. Let's go. Are we ready to bring the jury in?
Is there a chance of finding out who the rebuttal witnesses are so we can see if there's discovery issues or
Yes,
whatever?
and then we have to, at some point in time, deal with the Mr. Donnelly issue. So we could do that after we've talked about it. Who's the witness that you're going to call next?
First one will be Adam Pollock.
All right, and can you tell us who the second one is going to be?
David Lee.
David?
Lee.
Thank you.
Okay, they had a third. I just didn't know.
They didn't know if they were going to call that person tomorrow or not.
I have to ascertain his certain availability, Your Honor. I just haven't.
When you find out tonight, would you please email the defense and let them know so they could be prepared for that in the morning?
Yes, Your Honor.
Thank
And I
you.
know the state understands that they are bound in true rebuttal. Mr. Pollock testified before. I want to make certain this is not just a re-examination of him, but it is truly in rebuttal to some particular fact that we presented in our case.
If it's not, you're free to object, and then I'll roll.
Yes, Your Honor.
Are we ready to bring the jury in?
The defense is,
Yes, Your Honor.
Okay, you need to again rest on the record.
I'll do that.
In front of the jury, I mean. Please bring the jury in. Okay, Mr. Manti?
You asked for additional potential citations to authority, Your Honor. I would tender one, McKee. Necessary to inform the jury of any motives regarding, in this case it was a prosecution witness, but I think it applies equally. So again, in addition to the Britton case that I cited, the evidence would be admissible for that purpose. But that's not calling him to impeach this witness. If this witness denies or says something that is contradicted by the actual written record, then it may be necessary to impeach him, but I don't think he's going to deny that that's on his website. He may offer an explanation. That wouldn't be calling.
What is within the website that would contradict any evidence offered by Mr. Root?
Well, I don't know that. Well, as far as contradicting, he said that I believe he characterized Mr. Pollock as uninterested or unbiased or one of those, that characterization. I forget the exact word he used. but that he placed extra extra weight on his consultation for that reason. So it would not necessarily just contradict. I think it's also either contradict or help explain.
Okay, defense.
It has to, if it's impeachment, it's impeachment, and it has to impeach something. So let's talk about what it's being presented for. And we read from the same Bible, so I looked at Earhart for some insight on this, and what he says is that it actually has to be relevant. It has to truly impeach or address an issue of bias. In effect, if what we're looking at is this witness's, Mr. Pollock's bias and how he may have presented in a way that evidences his own personal financial interest, which I guess is the underlying request of the state, that they impeach or make believe not impeach, but impeach this witness by saying, you might be trying to make money on Mr. Zimmerman because he came to your gym. Let's just think this through for a second, and I think the court has to include within its context of authority common sense. So let's look at it through common sense filter for a moment. This witness who wants to tell somebody to come to his gym because I trained Mr. Zimmerman got in front of this witness, in front of this jury, and under oath said he went from a 0.5 a year when he first got to me to maybe a 0.1, that he was soft then and he's soft now. There's no financial interest that this witness furthered by his testimony, and that's why it's sort of bizarro impeachment, because it doesn't impeach what it would normally impeach. If this witness came in and said, this guy is great, and because of my training, he can kick anybody's butt, then maybe I would come in and say, wait a minute, aren't you making money by saying that you do a great job? We don't have that. We have the opposite of that.
Okay, what we have here and what the state had cited to the court was Britain versus State, 414 Southern 2nd, 638, and it is a 5th District Court of Appeal case. And in that case, the state didn't call this witness in their case in chief and called him in their rebuttal. And the court indicates that rebuttal evidence explains or contradicts material evidence offered by a defendant. And the testimony delivered by the state's rebuttal witness was neither explained nor contradicted any evidence offered by the defendant in that case. Permitting the testimony, however, was not error because the court has discretion in the order of presentation. What you're trying to do with Mr. Pollock is not an order of presentation. It is to impeach your own witness. You're calling him as a witness to impeach him by saying that he's advertising on a website about the Zimmerman trial and the Zimmerman training that he received at the gym. I don't think that that's allowed, and I'm going to sustain the objection.
Very well, Your Honor.
So I don't know how you want to handle this in front of the jury. We could tell them that Mr. Pollock is not going to be testifying, and you could call your next witness. Or we could have him come on here if you have any other questions that you wanted to ask him. This was the sole purpose?
Yes, Your Honor. I was going to call him and ask him about that particular website advertisement.
All right. Well, then the state agrees based upon the court's ruling. There's no reason to have Mr. Pollock come back into the courtroom?
Yes, Your Honor.
All right.
The next witness similarly has some objections to the presentation. May as well take that up before the jury comes back in, if we could.
All right, and the next witness's name is, please?
Is Mr. David Lee, Your Honor?
All right, and what is the purpose for calling Mr. Lee?
Judge, could I have just a moment?
Yes, you may.
Judge, on balance, the state is not going to be calling Mr. Lee.
Right, and how about the other witness that the state was going to check on for tomorrow?
I haven't left the courtroom to be able to check on that, Your Honor. I haven't yet known.
Surprisingly, we have an objection to the presentation of that evidence as well, maybe to address it.
Maybe we can proffer it. What is the name of that witness
He is Mr. Fleischman, Your Honor.
and his first name?
I believe it's Arthur.
Arthur? And what is the objection to that?
Who is it?
He is the agent with the Bureau of Alcohol, Beverage, and Tobacco for whom the defendant was arrested for committing a battery on a law enforcement officer. That is who he is.
Okay, and the purpose for calling him?
Because the defense has gone to great lengths to assert that the defendant is, despite all the other circumstances, largely incapable of fighting. I think this agent would offer a different perspective on that, where he could be permitted to testify. Specifically, he would essentially say that while he and some of his fellow law enforcement officers were engaged in arresting some persons at a bar at which the defendant was, that they had the individuals outside subject to being arrested, and the defendant came out. One of them, or at least one of the people being arrested, was one of the defendant's friends. The this agent in particular will say that he identified himself to the defendant, showed him his badge and identification, told him that he needed to leave while they were effecting the arrest of these individuals, and the defendant actually attacked him. That would be his testimony.
My response, Ron? One, it's a prior bad act that the state is trying to get in improperly, firstly. Secondly, of course, there's a 403 analysis that needs to be done by this court. Thirdly, you need to probably know a bit more about the facts of the case just so you can address it. The agents were undercover at a location out by UCF and had taken a friend of Mr. Zimmerman's out bodily because
Can I have a time frame in this, please?
It is 2005, Your Honor, so we're talking 8 years ago. Before, just so the court's aware, before he wanted to become a prosecutor, before he got his concealed weapons permit, where they did a background check, before he did the ride-along with Sanford Police Department. The reason why all of that was probably able to be accomplished by Mr. Zimmerman was that in 2005, when these agents grabbed his friend, who seemed to be underage, dragged him outside, and I think they'll probably acknowledge that that's how they accomplished it. Mr. Zimmerman, since they were in plain clothes, I think the officers will say that at some point they brought out their lanyards, but I think this court, previous court, Judge Lester, when he addressed this very same issue, I think opined succinctly that the way that these things are handled out by UCF is that the agents go in there sort of, I don't know if he used the word Gestapo, but something like that. Anyway, so they take him outside. Mrs. Zimmerman goes outside to ask exactly what transpired. The officers didn't like the idea that someone was getting them in their way of what they thought that they were doing properly. And they arrested Mrs. Zimmerman. I never heard that he attacked him. I don't think that's in the police report. Maybe Mr. Manti can proffer the police report to the court. But in any case, he was arrested for battery on a law enforcement officer. That went to the state attorney's office, who dropped it down immediately to a misdemeanor, which you know from your experience, they hardly ever do on true police victim crimes. They just don't do it, and they're told not to. Not only did it drop down from the charge to a misdemeanor, but then also opposed to the normal procedure of a case like this, it went into pretrial diversion. Having gone into pretrial diversion, he successfully completed that. They dropped the charges completely. So 8 years ago, he was in fact over-arrested for something. The initial prosecutor to review it identified it as being an overcharge, dropped it down to misdemeanor, pretrial diversion, and it was dismissed outright. It bears no significant probative value, both because it's ancient in time, it's ancient in act, and the way it was handled by the system suggests that it was a non-event even to begin with. I want to make sure that we're clear, however, that if in fact the state brings in this one prior bad act, suggesting that my client is now a fighter or something, that the very witnesses that the state attorney's office has relied on throughout this case, particularly those interviewed by the Florida Department of Law Enforcement, and most particularly the Federal Bureau of Investigation when they did their "Are You a Racist?" interview of everybody who my client talked to, including family members, a lot of people from Retreat.
Okay, can you get to your point?
The point is that there are probably 30 witnesses to counter this one witness that my client is peaceful, nonviolent, friendly, mellow, and everything else. Information the state, and the reason why I present it now, information the state is well aware
I told you
of.
when we're at the bench, I really don't like these, you know, you do this, I'm going to do this argument. Everybody, each side is available to present whatever case that they want to present within the bounds of the law and the rules of evidence, and they do so at their own peril for opening any doors that may be available. So I don't, you know, you all are experienced lawyers and you know what you can and cannot do or should and should not do. So I don't want to hear, if you do this, I'm doing that. That will be based upon a ruling from the court as to whether or not any particular door has been opened from either side. Mr. Manti, you have indicated that you don't even know if this witness is available. We now know what information you seek to elicit from this witness, and we can have argument if he is in fact available and you're seeking to have him testify. We can have argument before he testifies. Are there any other rebuttal witnesses that the state would be seeking to call?
No, Your Honor.
Right. Based upon that, I don't know if you're going to have any rebuttal, so we'll wait to see whether or not.
There's been no rebuttal. I don't think it's appropriate.
Well, I don't know whether or not.
If you allow this, I'm sorry.
Right. So we'll take that issue up tomorrow. I would like to then inform the jury as to where we're going in this case. So there will either be some more testimony in the morning. We'll do our jury instructions tonight, finish them up in the morning, and I'd like to tell them that we're going to start closing arguments tomorrow. How long does each side anticipate that they will take in closing?
Since we have opening and closing in terms of, I would say 3 hours.
I presume that only one attorney will be handling closing for the state, correct, as per your normal course?
Well, I think in any other times that we allow another attorney to do the rebuttal, I've always done it that way, so if that's how they choose to do that.
I object.
Okay. Your objection's overruled.
I think 3 hours is certainly enough.
Are there going to be a lot of conversations or rulings having to be made by the court concerning the jury instructions, other than what we do with a self-defense instruction in light of the Supreme Court's review of that instruction?
There's that. There's an addition based upon a case that I've just mentioned to the state but can present to the court as well as Gibbs versus State, which is a slight modification to the self-defense instruction to identify a word that's not otherwise defined. I'll tell you now, I'll tell you when we get together. Then there is a circumstantial evidence one that I think that has certainly been presented to the jury as an existing element for them to consider. And
when do you anticipate having your proposed instructions to both the state and the court?
I told him I'd get it to him tonight, so I'll get him the case law and those are the two instructions. We have some argument on the inapplicability of manslaughter to the facts of this case. I'd like to argue that with you at some point. I think those are the three main, with consultation with Mr. West and my client. There may be a couple of other polishings, but I think that's the
How
focus.
long do you think that argument is going to take on the jury instructions? I'm just trying to get a feel for time.
Oh, I think half an hour. I mean, I think it's pretty straightforward. Circumstantial evidence is what it is. I think it's discretionary with the court, but when the facts support it, it's allowable, so I'm not going to retrain anyone on that. The Gibbs case just defines provoked because it's not otherwise defined.
Okay, and if you're not ready to present that to the state yet, I'd rather wait for the argument. I'm just trying to get a scheduling idea right now. If I were to release the jury to recess for the evening and bring them back at 10 in the morning, the state can start their 2 hours, if there's not going to be any further rebuttal, could start their 2 hours portion of their closing statement. They could go to lunch. the defense can do their 3 hours and the state can do their hour rebuttal, and we can get it to the jury by tomorrow evening or have them recess for the evening and come back Friday morning. I'm going to leave it up to them as to how long they would like to do that for. So
Is now an opportunity, maybe after the jury's
we need
released,
to do the Donnelly hearing
to
also.
Donnelly and also to address the issue of their rebuttal? And the reason why I suggest that now rather than tomorrow is if you allow that, we may well have, I don't want to use the quid pro quo argument to you, but that's going to take a lot of work to get rebuttal witnesses together, a great deal of work, including all the other witnesses to that event and the other
Well, none of
things.
this may even occur if that witness is not available. Is there any way that you can let this court know sometime soon whether that witness is available at all?
Yes, Your Honor, I'm trying to check now, actually.
It may be a non-issue.
Okay, then we'll wait to see if we need to have the argument, I guess. Okay.
Let's go ahead and bring the jury in, and I'll excuse them for the day, and then we'll begin on Donnelly. Go from there.